Hello and welcome to Moneylife. This is Sucheta Dalal. This week, I bring you another topic, which is class action lawsuits. Now, what is a class action suit? When many of us individually, as small investors, depositors, lose money, and we are not alone, there are thousands of us. What happens? You can't individually go to court because it's just too expensive. So most of the developed world has what is called class action, which means that a bunch of investors, depositors, subscribers get together and file a litigation so that costs are divided among all of them and it's possible to fight collectively together. Because each time you are facing somebody who is very powerful financially, has financial muscle, is able to get the best legal minds. And as an individual small investor or depositor, debenture holder, you are up against somebody large that you can't fight. So when you are a group, 100, 200,000, then the David Goliath situation sort of equalizes and you have a little more power. And when so many people are affected, and that's demonstrated, it makes a difference even in a court of law. Now, does India have class action? Believe it or not, when the companies bill was amended in 2013, class action lawsuits were introduced in India for the first time with a particular provision, Section 245 of the Act. But 11 years later, I'm doing this video blog because for the first time, you actually have two class action lawsuits in court. The hearings have begun, and this is a matter of celebration. So why has it taken 11 long years? Because I guess people do not want us small guys to be empowered. So the rules and clarifications were introduced through an amendment. So it was toothless, it was unworkable in 2013. Finally, in 2016, there was an amendment that gave it some teeth. Even that was not good enough because they had still to clarify and issue rules on what is a class. When I say class, it means, like, think about a school. You have 40 people in a class. So what would be a class to file a class action suit? That has to be specified, defined by the law. This happened only in 2019. It's called a threshold. I'll come to that a little later. But only when these two things were done, finally in 2024, we have class action. Like I said, class action has immense potential to protect minority shareholders, depositors, investors from corporate wrongdoing because we're able to fight as a class. But we, the investors and small guys, haven't really pushed for it or demanded that it should have teeth. And we should have a situation where we can fight against a legal system that's slow and expensive. Now, what were the two amendments? In 2016, they simplified procedures and eligibility criteria for filing class action. They also, in 2019 May, specified the threshold. So under this, 5% of members, so say it's members like a company, equity shareholders, that 5% of them in an unlisted company or 2% in a listed company will form a class, or 100 members, whichever is lower. Similarly, if it's depositors, 5% of total depositors or 100 members, whichever is low. Now, 100 seems small when you're thinking of situations where tens of thousands of people have been cheated, whether it is home buyers or whether it is people who have lost money to brokers or ILFS. But well-known financial consultant Vinod Kothari, when I asked him about it, and he's written an article, he points out that the US does not even have a minimum number. One person can file a class action on behalf of the whole class of people affected. Australia requires only 7. Canada permits, again, a single shareholder to file an action. We have a huge hurdle. 100 people have to come together. On the positive side, like I said, doesn't matter the high hurdle, 2 cases have been filed. Which are these 2 cases? One is Jindal Polyfilms and the other is ICICI Securities. In Jindal, a small group, 3 or 4 of them, so they're minority shareholders, but together hold 4.99% stake. They have approached the company, National Company Law Tribunal, NCLT, Delhi, under Section 245 of the Companies Act. They have alleged gross financial mismanagement of this company, Jindal Polyfilms, fraudulent conduct, and they have alleged a loss of 2,500 crore. The petition has sought judicial intervention to investigate irregular transactions, undervalued sale of financial instruments, how money was paid to bail out a group company in a one-time settlement, then loans were written off, there was sale of shares to related parties, all this eventually ending up with losses to Jindal Polyfilms and thereby to the minority shareholders of that company who have filed the petition. The case is going on. It's going to be next heard on 11 July 2024. The second case is ICICI Securities. More interesting because in this case, a portfolio manager, Manu Rishi Gupta, has taken the lead to get together 100 investors to qualify as a class under Section 245. They have claimed significant and deliberate undervaluation of ISEC, which is ICICI Securities, by as much as 40%. They say old data was used by the valuers, so the swap ratio was decided in a manner that was against the interests of the minority and helped the parent ICICI Bank. How does it help the parent? Because ISEC, after delisting, is going to be a wholly owned subsidiary of the parent, and what the investors get is very little because of the undervaluation. ISEC and ICICI, obviously heavy financial muscle, have challenged the class action on various grounds, starting with jurisdiction, starting with the composition of the 100 investors. But the case has been heard once, and this too has been posted in for July hearing. Why July? Because courts are on a summer vacation just now. Now, what does this petition want? It wants the whole e-voting scrapped and declared null and void, and thereby the delisting. Let's see what happens. These two cases are an important milestone because they expose the limitations of the current framework as well. In ISEC's case, remember, there's one more point, which is an exemption that was granted by SEBI. So it is also interesting because the Securities and Exchange Board of India has been made a respondent. And don't forget, the SEBI chief once was with ISEC and headed it. So lots of interesting factors coming together here. We're going to watch what happens in July. But what we're more keen on is this larger issue of class action. And if you ask me, these two cases expose the limitations of the current framework. Why? Because it restricts it to specific groups of people. Depositors of a company, fair enough. Equity investors, fine. But if you're looking at depositors, why exclude bondholders, debenture holders? And then what about another big class which puts in hard-earned money and has been rampantly cheated from 2018 onwards? These are home buyers of large realty companies. So many of them have gone belly up. Each of these people wanted that one house roof on their head, and they have been fighting case after case through various levels. And these bankrupt companies still have enough of money to hire the best lawyers and keep fighting against them, file review petitions, go to the Supreme Court. This is why you need class action, because every group that suffers due to corporate mismanagement should be able to get together and fight. There are a few more things that they need. We'll come to that later. Now, you would wonder about home buyers. I've already mentioned them. One group of home buyers actually has been very successful. So they ignored the Companies Act and they went under the Consumer Protection Act. Under the Consumer Protection Act, you can file a class action, provided you do it as a group of members and then it applies to them. So they filed under Section 12(1)(b) of the Consumer Protection Act. And this was a group called Akriti Aquacity. They actually had to register a society, form this association as a society, and then file the case so that these members who became members of the society, who are probably paying for the litigation, get the benefit of any order. It is tough, it is slow, but they got a fantastic order from the Apex Consumer Court, the NCDRC. Naturally, it went to the Supreme Court. They've got a good order from the Supreme Court as well. But it is not over. There's a contempt petition because that order has to be obeyed and implemented. So it's not happening. They also turned lucky because the Madhya Pradesh Real Estate Regulatory Authority was part of the petition, and MP Rera obviously had equal clout and strength to be able to fight. So this worked as a class action because of many circumstances, not only the doggedness of the home buyers, but because they had help and MP Rera was standing along with him. Now, the case is going on, the contempt case is going on. The good news is, as recently as 2 days ago, 16th May 2024, the Insolvency and Bankruptcy Board has suspended the insolvency professional involved here for all kinds of shady activities that he was doing. His name is Anil Goel. This man has been indicted even by the Delhi High Court. But like I said, the fight is slow and it goes on. In fact, the struggles of Akriti itself show why you need them included even under the Companies Act as a potential class. The current provision limits eligibility, like I said, to shareholders and depositors. Another group that needs to be included are bondholders. So remember, or we have done video blogs on this, two banks, Yes Bank and Lakshmi Vilas Bank. There were people who bought their additional Tier 1, AT1 bonds. In fact, Yes Bank fixed deposit holders were sold these banks saying bonds as saying they're safer than fixed deposits. And then when the resolution happened, Yes Bank was taken over by a consortium led by SBI, Lakshmi Vilas Bank by DBS. At that time, these were just extinguished, which means that whatever money you put into those bonds, the AT1 bonds, whether 10,000 rupees or 10 crores, was just wiped out. Obviously, it's a huge loss because you invest in bonds as part of your safety net, your nest egg. These depositors are in court. They have tried to form groups and they are struggling. They have got orders, some of them favorable. So the Bombay High Court ruled in favor of Yes Bank depositors. The amounts were not small. It was 8,415 crore which was written off. So Bombay High Court ruled in their favor. They rushed to the Supreme Court, got a stay order. The Supreme Court has said that, you have to be fair to them, ask questions, case is going on. Lakshmi Vilas Bank case is also still in progress. Third battle, which is all the defaults after 2018, one of them being Infrastructure Leasing and Financial Services, which had issued non-convertible debentures. Here also, the depositors have formed a group. They're fighting a battle, but like I said, an unequal battle. They have contested the restructuring plan. They want more equitable distribution. They want to be considered financial creditors. It drags on. Small amounts have been paid, but it's a slow process, which is going on from 2018. In fact, the facility of filing class action, according to me, should be extended to more categories. Remember Sahara? Some investors have died by suicide and nothing is happening. The case drags on through court. There is no proper class action over here, even though the government has said it's doing something. It's too little and not yet working. And an intervention that we have filed has not even come up. Then there are all kinds of Ponzi schemes. There is Pearls, there is Pan Card Club, Alchemy, Rose Valley, Sharda. Most people have got nothing. Some have been decided by SEBI. There is a former Supreme Court judge in charge. Small amounts of money are distributed, but by and large, people have got nothing because the process is too slow. And they do not get included as a class. Now, we talked about who should be included in a class. That is one part. What is the way forward for this really to work? It is not just to expand the scope of class action suits, but you need to have a comprehensive legal framework where contingency fees to be paid to lawyers should be allowed. What is contingency fees? It means that a lawyer takes on your case. You're not paying appearance by appearance. When the case is decided, you commit that you will pay a percentage of what you get to the lawyers. So if you lose, the lawyer doesn't get anything. But if it's a large group and you win and you've got 1,000 crores, you may have committed 30%. You have to pay that 30%. The lawyers get a hefty payoff if successful. This means their interests are aligned with those of the class of people who've been duped, and they put up a good fight. They helped to create this group of 100, because getting 100 people together, believe me, is not simple. We at Moneylife Foundation have attempted it several times. It's very, very difficult. So clearly, without significant legal reform, true class action is not going to be a reality. And part of this has to be payment of contingency fees to law firms. The time has come. If it works around the world, it has to work in India. And it is not enough for us to watch these two cases. These two cases will hold significance for us. We need to fight to get the rules changed, because nobody fights for the small guys. And most of you who are watching this video are the small people like me. If you agree, share this video because you're sharing knowledge, and subscribe to it. Thank you.